Hi guys, good morning to all of you all. Now today is again a very important topic. Whichever topics I'm covering in the marathon, I'm covering it in full detail so that your chapter is actually over. You can keep your books aside. I cover the past year questions as well as from the module. Today again, I will be covering few chapters from your company law so that much headache is out. Now, whenever I'm teaching, I advise all of y'all to keep your modules, your institute modules, which you have got from the ICSI with you. Okay, so when I cover from the modules, I will be giving you all markings and you all can simultaneously cover. Okay, I have noted down and the chapters that you all have difficulty in. Okay, and I will be covering today the deposits chapter first. Okay, so just before I start, if you all can give me a thumbs up if I'm audible and visible to you all. Okay, and we are good to go. If you want to share the links with your friends, go ahead, please share it. Okay, and inform them that I'll be starting and finishing the deposits entire chapter, which is your lesson 4, debentures and deposits. One lecture I've already taken. You can check the live session where the debentures entire topic was covered. Today I'll be covering entirely deposits. Okay, so a thumbs up from y'all that y'all are all ready, set to go. Thank you so much, Jyoti, Jack, Afreen. Okay, am I audible now? Am I perfectly audible now? Quickly, am I audible to y'all? Thanks, Jack. Just a thumbs up if I'm audible, please, so we can quickly begin. Okay, now understand one thing in your company law. Yes, great. Good morning, Sam, Murali, Purnima. Great, sorted. So this chapter, the biggest chapter, the most toughest chapter which people feel, I can tell you for sure, I'm going to make it so simple for you that on listening the lecture you will be able to attempt all the questions. And trust me, this chapter is among the important chapters, not only from exam point of view but also professionals and also in practical life. Okay, so we will be starting now. Hi, so we'll be starting with the deposits chapter under company law. Now let me tell you one thing, that companies today require funds to do business. Now these funds can be of two kinds. One is your own funds where they raise from shareholders, equity shareholders, and use the money. They give them equity rights in the company. The second type of fund source of fund is borrowing or debt capital. That is, we take loans. Against the loan, the company will give interest, and on the maturity date, they will repay the principal amount also. So deposits is a kind of a borrowing from the investors. So a deposit holder will get interest, just like as when we take loans from banks, we give them interest, and on the due date we give them the principal. Now I want to know from you, do companies, the board of directors have power to borrow money? Yes or no? Obviously, every time the board of directors do not have to go and ask the shareholders that can we borrow money. Under the Companies Act, under section 179 subsection 3D, the board of directors already have been given the powers by the act itself, Companies Act, to borrow money to do business. So let's read it. The board of directors of the company shall be entitled to do the following, that is, they have a power to borrow money. So does the board of directors every time have to take consent of the shareholders before borrowing? Answer is no. They already have inherent powers by the act. But does that mean that the board of directors can borrow unlimited money, or there is a limit on the amount they can borrow? That is your interview question also, where they ask what is the maximum amount that the board of directors can borrow? So the answer is given in very next section, that is your section 180, subsection 1, subclause C, that gives you the restrictions on power of board, where it says that what is the maximum, or they also call it as the borrowing power of the board, borrowing power of BOD, the maximum loan that they can take, beyond which they cannot take it themselves. They have to go and take approval from the shareholders by way of a special resolution. So let's see what is the limit given here. The board of directors shall exercise the following powers only with the consent of the company by special resolution. So to borrow beyond the limit, they have to go and ask the shareholders by way of special resolution. Now what is that limit given? To borrow an amount, okay, along with what they have already borrowed, that is the total borrowing, if they want to do, if it exceeds paid up capital plus free reserves plus security premium, okay, apart from temporary loans. So what is the borrowing power of the board? The board can borrow max how much? 100% aggregate of paid up capital plus free reserves plus security premium account. This is how much borrowings they can take. Clear? How much borrowings the board of directors can make. Till here it is clear. If they want to go beyond that, beyond the limit, then you have to take a special resolution. Okay, please note this. Now coming to ultra-wise borrowing. Now this is also very important. They have asked in the past exam question as well. Ultra-wise borrowing. That means, and who is going to be responsible for ultra-wise borrowing? For example, here we have the BOD, the board of directors. They have went and they have taken a loan from a bank. Let's say they have taken a loan from a bank. In this case, we'll give HDFC Bank. They have taken a loan from HDFC Bank. The only issue was this loan was not authorized. The bank gave the loan. And board of directors did not take requisite approvals. Now, so we will call it as a ultra wires borrowing. What do you mean by ultra wires? Means what? Ultra means beyond and wires means powers. So the board of directors have gone beyond their powers and borrowed money. Now tell me who is going to be really shocked and scared? It's obviously going to be the bank who has given the loan. That my money is gone, I have given money, मैंने लोन दे दिया और ये तो बाद में पता चला कि unauthorized borrowing है. I have given the loan. Later I came to know, the creditor came to know later that this loan is unauthorized. The board of directors have wrongly taken the loan. Now my question is, who's going to pay me the money? Will I file a case on BOD or is the company liable? Who's liable? Or you would say both. What is the answer? So the answer has been divided. Okay, the answer has been divided of who's going to be liable. Let's see. I'll give you first the framework. They've divided it into two categories and then I will explain you with the rights of the creditors in case of ultra vires borrowing, unauthorized borrowing. So unauthorized borrowings have been classified in two categories. One is ultra vires borrowing, that is outside the company's authority. That is, company itself doesn't have the rights. In the MOA, AOA, the restrictions are mentioned. So here the MOA or AOA has the restrictions, clearly mentioned. Clear? And the second type is intra-vires borrowing. Intra-vires borrowing means what? It is within the company's power but the outside the director's power. So it is within the company's authority but outside the director's authority. So here the restriction is mentioned, the powers are mentioned in MOA or AOA. Now question is, who's going to be liable? Can you all put in category 1, who's going to be liable? Let's take an example. In the act, in the AOA, it is clearly mentioned that the maximum loan is 3 crores. That the company can take maximum loan is 3 crores is mentioned in the articles. So who's going to be liable? The company will be liable or directors? See, in this case, since it is outside the company's authority and AOA and MOA are public documents, these are public documents, the creditor should know. Creditor should already know that, listen, these are MOA, AOA are easily available. Even you can go and extract MOA, AOA of any company. So the creditor should have done the research. Okay. This is doctrine of constructive notice. That means the outsiders have constructive notice, that is a assumed knowledge about the MOA, AOA, and they should have known that the maximum loan is 3 crores and they have given loan of 4 crores. Clear? So in this case, who will be held liable? The company is not liable, because company will say you should have read the MOA, AOA, file a case on directors. Okay, not on me. Now the second case scenario is, it is written in the AOA, it is written in the AOA. Now I want you all to put in comment and tell me, the AOA has clearly said that the maximum loan, max 3 crore loan can be taken. The BOD has taken a 2 crore loan without approvals. Without approvals. Clear till here? What happened is, it is within the rights of the company, it is within the powers of the company, it is within the authorities, company's authority, but outside the directors authority. That is, the directors had to take some approvals, but without approvals they went and they took the loan. So now who will be held liable? Can you tell the creditor go and fight against the directors? What the creditor will say, what HDFC Bank will say, listen, I have read your MOA, AOA, I know about the AOA where the maximum loan is 3 crores. So I have read the public documents. I do not know what happens indoors. What happens within you all, whether the approvals are taken or no, how will I know? So why should I be affected? Here the company will be liable. He can sue, the creditor can sue the company as well. Okay. Why? Because the MOA, AOA, the bank read. What happens indoors, as per doctrine of indoor management, the creditor can sue the company. Another thing, here the rules of principal and agent, the rule of agency will apply, where the directors are the agents and the company is the principal, and therefore we will say that the agent has done something wrong, so the company should be held liable. So the companies will be primarily liable, and if they lose this case from their accounts, it can be held liable. Okay. Now let's take this example in the first scenario where the creditors will get a shock that company is not liable. So what are my rights? If the company is not liable, then what are the rights of the creditors in this case? What do you think the creditors can do? Quickly put in the chat box, where the company is not liable, what can HDFC Bank do here? So unauthorized borrowing or ultrawise borrowing. So we will see where a company borrows without the authority conferred in its articles. So the power is not within the articles. Such act is ultrawise is void. The lender cannot sue the company for return of loan. Clear till here? So this is important. Ultrawise acts which is beyond the MOA AOA cannot be ratified even if all the members are approving. So this cannot be ratified only, and lender cannot sue the company because it is outside the article. So it is doing a borrowing which is outside the articles of the company. So the company will be protected with under the doctrine of constructive notice, deemed knowledge that the creditor should have known this knowledge by reading the public documents. Now question is, we understand that the doctrines are there, but what is the remedy available to the lender in such a case where the company is not liable? So we will see that अगर एक बैंक ने लोन दे दिया, if a bank has given the loan and that loan is beyond what the company could borrow and the loan is beyond जो कंपनी बोरो कर सकती थी, तो अब कंपनी बैंक करे क्या, रिकवरी कैसे करे लोन का, हाउ विल दे रिकवर इट? सो देन दे हैव गिवन यू 3 ऑप्शंस व्हाट दे हैव. फर्स्ट इज इंजंक्शन. The lender has the following rights. First is injunction, where they'll immediately go to court and they will tell the court, listen, we have transferred in the company's account, pass an injunction and stop the company from using the funds. See, I'm not making them liable, but at least I can restrict them from using the money. So this is my powers. This comes under the doctrine of equity, that is fairness. The courts will order. If the company has not spent the amount so borrowed, the lender may obtain an injunction order against the company, restraining it from spending the amount and recover the same. If the amount has been invested in some asset, then the creditor can claim that asset. If they have bought a plant and machinery, they will say, give me the plant and machinery. Okay. If such asset cannot be ascertained, then he may claim repayment if he can prove that the company has benefited from such borrowing. Means what the creditor has, if the money is spent or not spent, you have to see whether it is spent or it is not spent. If it is not spent, immediately get a injunction, that is stop them from using. If it is spent, then you have to follow the benefit. Find where the company got the benefit and tell that much benefit the company got. The benefit, I will take it, the asset I will recover it, and I will take the benefit which the company got from my loan. The next power of the creditor is right of subrogation. Now what do you mean by subrogation? Subrogation means substitution. Let's understand. So they have given a very specific scenario here. एक particular example दिया है, in which we will see how the bank gets substituted, okay, to something else. Let's see. Where the money of an ultrawise borrowing has been used to pay lawful debts of the company. मेरे पैसे से किसी का लोन भर दिया, मेरे पैसे से जो तुमने wrongly लिया, from my money which you have wrongly taken, you have paid off your loans. He would be subrogated, then the bank will be substituted in the position of the creditor and would have the rights to recover the loan from the company. Let's understand what happened. What happened is, our company is there, company XYZ. Ours is company ABC. Okay. The bank, HDFC Bank, okay, gave a loan, a Ultrawise loan. Whatever, the bank manager was unaware, whatever reason, the HDFC Bank made the mistake. Okay, they did not read the MOA and granted the loan. They gave the money. With this money, the company, that is the borrower, what did the borrower do? The borrower, what did he do? He had some loan. He had a creditor, past creditor. With this loan amount, he repaid the loan. with my loan amount. Imagine I gave him 2 crores and this 2 crores he repaid off his loan. Now the question is, HDFC Bank came to know and got a shock that first shock they got that it is a Ultrawise loan. Second shock they got that with that money he has repaid his previous loan. So what rights do HDFC Bank have? So HDFC Bank will now be substituted in the position of this creditor. So as they had to repay, they paid 2 crores here. So now HDFC Bank will become the creditor and they will recover this loan amount. So they will be deemed creditor. That is, this guy will leave. He got his money. In his place, now HDFC Bank will come. How company ABC, for them, the original creditor was this guy. Now this guy will go, and now for company ABC, the creditor is the HDFC Bank. Clear till here? So they move out, this new creditor, the HDFC Bank will now be the creditor and they will recover this money from the company, as all the rights which the past creditor have, this creditor will have the right. Common sense. So what is happening is, the bank gave the loan to the company paid off to the creditor. Okay, so now this creditor is out. The bank will be substituted in the position of this creditor and they will now be the creditors for this company. Clear till here? So this is what they have given for substitution. So creditor, so original past creditor will move away and I will come in his place as a new creditor. Clear, to recover the amount given. Let's read what is given here. Where the money of an Ultrawise borrowing has been used to pay off a lawful debt of the company, he would be subrogated to the position of the creditor paid off and would have the right to recover his loan from the company. And law also allows it. Why? Because the company's total, that guy will move out and new guy will come in. So the company's existing liability remains the same. First I had to pay 2 crores to him. Now I have to pay 2 crores to the bank. Substitution is allowed for a simple reason. When a lawful debt has been paid with an Ultrawise loan, the total indebtedness of the company remains the same. 2 crores you gave him, you were liable to pay him, now you are liable to pay me. So the debt amount remains the same. By subrogating the Ultrawise lender, the court is able to protect him from loss and the burden of the company is nowhere increased. Next, suit against directors. Now obviously if you can't sue the company, you will go ahead and sue the directors in personal capacity and try to recover them the money from them. Clear till here? So in case of Ultrawise borrowings, the lender has three remedies. Okay, one is right of substitution if a loan has been repaid, that is called as subrogation, right to go against the directors, and last right is and the third right is to get an injunction stopping them from using the money. Okay, and if they bought an asset, to take possession of the assets. Clear till here? Now we'll look at a scenario where it is intra-wires of the company. So it is ultra-wires of BOD's power of BOD, but intra-wires within the powers of company. Then what will happen? So let's understand. Very simple, interesting point. Okay. Now in this case, intra-wires borrowing but outside the scope of the agent's authority. So what the creditor will say, it is company within the powers. I read the AOA, it is within that. So, and what happened indoors, what happened within your approval and all that, how will I come to know? So I will put a case on the company and recover from the company. The company can file a case on directors, that is different. Sometimes company might approve the loan also. They will say, okay, fine, it is within our authority, we can approve it. They can ratify and say that the director has given us only the money, so we want to rectify also, ratify the loan, approve the loan. Where the director has borrowed beyond their authority, but the borrowing is not ultra vires of the company. It is called as intra vires borrowing, but outside the scope of the agent's authority. The company will be liable to such borrowings if the borrowing is within the director's authority and the lender acted in good faith. If the lender anywhere knew that the directors are exceeding, then they will not be protected under this thing, because it is only to protect innocent lenders or lenders who know that yes, the company's power is there. So where the borrowing is intra vires of the company but outside the authority of the directors, example where the articles have given the powers to borrow up till 100 lakhs but with approval of shareholders, and the borrowings beyond this without the approval is intra vires. So any borrowing beyond this without the approval, okay, is there, it becomes binding on the company. So simple point what I told you, that if it is within the company's powers, then the company will be held liable. Why? Because the principles of agency will apply. The agent did wrong, the principal will be held liable. The doctrine of indoor management, as we have seen, that what happens indoors, how will the creditor come to know? As given in Royal British Bank versus Turkwind, shall protect the lender, and you can file a case against the company. Bearing in mind, and in the first case, what happened is it was outside MOA. So bearing in mind that the MOA are public documents, contents of the third party is deemed to be known. That's constructive notice, deemed knowledge. But a third party is nowhere has knowledge or affected if indoor there is something wrong going on and the indoors the agents or the directors have not taken the requisite approval. Clear till here? So we understood borrowings. Companies can take borrowings. There is a limit on borrowings, and we've also seen the legal position of ultra vires borrowing. Now we'll be starting with the topic called as deposits. Deposits are nothing but borrowings, just like a loan. So as we see a typical loan, how does it work? There is a company, there is a bank or a creditor. The creditor gives a loan, okay, or I could say that the company borrows the money, and in return for getting the loan or the borrowing funds, okay, the company will give interest, and on the principal, on the due date, they will redeem the amount. Same is the concept of deposits. Deposits are also like a loan to the company, where there can be investors who will be creditors here. They will invest, that they will give small amount of loans. As you have shares, you have debentures, like that you have deposits. They will deposit 2 lakh rupees per investor, depending on what is the amount. The company will take the amount, they will say it is for 5 years, it is for 3 years, etc. And during that time period, the company will give interest, and on the due date, they will redeem. So this is the concept of deposits. Okay, now we will see what are the features of deposits, what are the rules of deposits, what are the timelines given, what are the necessary filings for deposits. Okay, now first let's see the regulatory framework for deposits. Okay, now deposits are covered from section 73 to 76A. So you need to know section 73 to 76A talks about deposits. Okay, I will make you all memorize every single section as well. Okay, 73, 74, 75, 76 and 76A. Then apart from that, there are rules. Okay, I will tell you which are the important rules to know as well. It is your company's acceptance of deposit rules 2014. Okay, let's see. First, deposits under Companies Act 2013 is coming under section 76 to 76A. The rules are given in Companies Acceptance of Deposit Rules 2014. It is covered in your chapter 5 of your Companies Act 2013. Now let's look at the definition and few sections. Okay, now pay attention to what I'll be saying. Section 2 subsection 31 defines what are deposits. It defines what are deposits. So they say that any receipt of money is termed as deposit. So company, if they received any money, it is termed as a deposit, but it excludes now all those things given under rule 21C. Clear? So they tell you what are not deposits. Okay, what are not deposits? Which rule? Rule 21C. It tells you what are not deposit. Not any receipt of money will be treated as deposits. If it is falling under rule 21C, it is not a deposit. And also we will see rule 21D. It defines who is a depositor. Who is a depositor? Okay, depositor is a person who gives the money, who makes a deposit with the company. And what is rule 21E? It talks about a eligible company. Eligible companies are public companies having certain net worth and turnover who can take deposits from public. That is, deposits could be privately placed and taken from certain members, their own shareholders. They can take deposits from them. But if you want to raise a public announcement and raise from public at large, okay, so for that public, then only eligible companies. We will see who are the eligible companies. They are eligible to do what? They are eligible to raise funds, raise deposits from the public. So obviously a public company will only be eligible to take deposits from public, but not every public company. A public company having minimum level of net worth and paid up capital as prescribed is only allowed to go and raise money from public. So let's see. So remember the rules that I told you and the sections. What section did I tell you? Section 231. What is section 2 subsection 31? It defined deposits. It says that deposits includes any receipt of money. जो भी पैसा आया, any receipt of money by way of a deposit or a loan is called as deposits. Then they go on to say, however, those mentioned in 21C, they are not deposits. Okay, so now they will give you a list of transactions which are not deposits. So if it is not a deposit, they don't have to follow the rules of section 73 to 76A. Clear? Let's see which are these items which are not deposits. Very, very simple also. First is any amount received from the central government or the state government. Okay, or any amount guaranteed by these governments. For example, my company is there and I have received from central government or state government or any local authority. So for this, they are the depositors. Deposit provisions will not apply. Okay, because they will give subject to some terms and conditions which will be independent, different only. So there are some rules for deposits which will not apply. Next, any amount received from foreign governments, foreign banks, multilateral financial institutions, foreign governments owned development financial institutions. So if there is an Indian government is giving money or a foreign government is giving me grants, for these grants, deposit provisions will not apply. Any loan received as a loan from a banking company, state bank, any of its subsidiary, etc. Common sense, if there is a loan taken from a bank, deposit provisions will not apply because the banking company will have its own set of loan agreement which we will follow. Here we are covering other than that, when you're raising money from taking loans from members, from public, for them we are doing, because you never have agreements with them individually, right? And they could be many, public could be many. Here we are saying we are taking a loan from bank, then they say it is not deposit, you all will be governed by the loan agreement. Next, again similar point, any loan received or any financial assistance received from PFI, public financial institution. So again, they are also financial institutions, they will have their own loan agreement, term sheet, etc. So we will go as per them. Okay. Any amount received against issue of commercial paper. Now again, commercial papers are these are, I don't know whether you know what are CPs. So high credit rating companies, high credit rated companies, that is, they have got a minimum rating of A2, okay, or P2 minimum. There are these ratings, they have got a minimum rating of 2, and they raise money in the form of unsecured promissory notes from the public, and these are short-term instruments. Now what am I talking about? I am talking about commercial paper. Now commercial paper has been governed by RBI, and they have already given rules, regulation, time frames, everything. So for that, then deposit provisions will not apply. You will be governed by those specific provisions of commercial paper. Then intercorporate loans, very, very important. Amount received by a company from another company will not be treated as deposit. So intercorporate loans, they are not deposit provision will not apply. Why like that? Common sense, we are trying to cover members, we are trying to cover individuals, we are trying to cover public who are giving loans, so we need to protect them. Other company will be able to protect, government knows what to do, bank knows what to do, financial institution knows what to do. So for them, their agreements, commercial papers also, all the rules and frameworks are already there. Here we are saying that received from public, received from members, received from individuals, they are deposits. If they become deposits, 73 to 76A will apply, and we will see how we are protecting the public. And you will realize that how well these rules are framed to protect the public from recovery of money, from ensuring that there is no default on repayment of their loans, etc. Another, any amount received towards subscription to any securities, including share application money, they shall not be termed as deposits. If we have taken subscription money, public are paying for subscription, is that deposit? No, it's for a specific purpose. Okay, but if I have taken the money and not given them share also, not allotted shares also, then it can be treated as deposit if I am not repaying within the time frame. Now what is this time frame? Mark it as important, it can come in your exams. That if the securities for which the application was made cannot be allotted within 60 days, then within 15 days from the date of completion of 60 days, such amount shall be treated as deposit under these rules. Okay, let's understand what it is. We are talking of public. Public have subscribed. Now there is a company. Company have the public have paid for share application money. Against this share application money, the company will obviously allot shares. So they are not treated as deposits. You are applying for shares, right? So that is not a share deposit and all the rules. So you are giving shares. So we say fine, कोई problem नहीं है यार. Application money के against allot कर रहे हो. against application money or allotting shares. So no problem. Absolutely. No, not a deposit. But if application money received and company has not allotted shares, they have not allotted shares within how many days? So they get 60 days time, 60 days time to refund the money and 15 days grace. So from the end of the 60th day and more 15 days. If within this much time it is not refunded, then it will be treated as deposit from 16th day onwards. And all the provisions of deposits will apply. So let's read it again. Any amount received towards subscription, okay, of money shall not be treated as deposit, because we are reading Rule 21C. If the securities for which the application money cannot be allotted within 60 days, so securities could not be allotted within 60 days, then the company gets 15 days from the completion of 60 days to refund the amount. If within a 15 days also they have not refunded, then such amount shall be treated as deposits. Okay, so 60 days from receipt of application money we couldn't allot, then company gets further and the amount is not refunded to the investors within 15 days from the completion of 60 days. That is total of how many days? They have given the money within 75 days. If 60 days plus 15 days, if in 75 days we have not given the shares nor the refund, then you are still keeping the money, then we will treat it as a deposit. Then next we see, again, director is given. You want to protect directors. Obviously they know what they are doing. So this, any amount received from a person who at the time of receipt of the amount was a director of the company, okay, or a relative of the director. So then we say, okay, fine, this is not a deposit. They know what they are doing. They will have their own terms and conditions. They will negotiate it. Let it go as per that. Provided that the director or the relative or of the private company, as the case may be, furnishes to the company at the time of giving a loan a declaration in writing that the amount is not being given out of the funds acquired by borrowing from others, and the company shall disclose the details so accepted in the board report. समझ में आया ये? What are they saying? That if the director has given the money, we say it is not deposit. Provided the director gives in writing that this is my own funds, my relatives' funds, I have not borrowed from anyone and giving, then it is not a deposit. Then next, if we go to see any amount raised by way of issue of bonds or debentures secured by first charge, or a charge having pari passu rights with the first charge, referred in Schedule 3, excluding intangible assets, or on any of the assets referred in Schedule 3, excluding intangible assets, or bonds which are compulsory convertible for within the next 10 years, and the valuation is not exceeding the market value as assessed by the registered valuer. So you got a shock of your life moment I read it. Yes or no? Have you understood? This is very important. Okay, let's see. Let me tell you what it is. What is first charge, etc. So let me explain. Okay, now this is the assets of the property. This is what? Assets of company. Can they be kept as security and taken a loan? Mortgage can be done. Yes, it can be done. It's called as charge. So we have a charge holder. Let's say we take a loan from HDFC Bank and I'll call it as charge holder 1. Okay. Now the same asset of the company, can it be kept as security to another bank? Yes or no? Can the same asset be kept as security to another bank? Yes, no. What is your answer? Now see, understand. If the asset is worth 10 crores, if the asset is worth 10 crores, and the first loan that I have taken is of 1 crore. So obviously the asset is of more valuable. I can take one more loan. I can take multiple loan. What is the problem? So now I go to ICICI Bank. I go to another bank called as ICICI Bank. Okay. ICICI Bank, again I take a 1 crore loan. 1 crore loan. Now this is also a charge holder. They also have rights over the property now. Charge holder. But tell me, if for some reason the assets of the property it gets destroyed and now the value is less, who will get first right? Let's say if this property got destroyed and now its value is not 10 crores, it is only 1 crore. Who will get this money? I want you all to put in the chat box. Will HDFC Bank get 1 crore? Or ICICI Bank will get, or 50-50? I want answers from you all. What do you think will happen? If the assets kept as security were of 10 crores when it was taken, charge holder 1, that is HDFC Bank, to gave a loan of 1 CR. ICICI Bank also gave a loan of 1 CR. Now the property value on time of redemption or selling, it got destroyed by fire. Now it is only 1 crore. Who will get? HDFC Bank or ICICI Bank? Quickly, or 50-50? I want you all to tell me. Now obviously understand, this is secured by first charge. First charge मतलब पहले लोन दिया ना इनको पहले सिक्योरिटी किया. So this is the first charge, and here they have second charge over the property. So ideally charge holder 1 is secured by first charge. Have you understood this line? Have you understood? HDFC Bank has been secured by first charge. So after reading the provisions of Rule 21C, read with section 2 subsection 31, tell me which is a deposit and which is not a deposit. The amount given by loan given by HDFC Bank is a deposit, or ICICI Bank is a deposit? Quickly, I want you all to put in the chat box. Very good. So what they have said, what is not a deposit? What is not a deposit? Any amount raised by issue of bonds or debentures secured by first charge. So they are not deposit. So this will be not a deposit. So this is not a deposit. Clear? This is not deposit. Okay? Because it is secured by first charge. This will be treated as deposits. Treated as deposits. Clear till here? Treated as deposit. So they have said that anyone who is first charge or who has pari passu rights as first charge, means there is another guy who has the same rights as the first charge holder. So whoever is standing first in line is secured. We don't need to protect them. We need to protect the second guy, right? We need to protect this guy. So that this is treated as deposits. If it is a deposit, all the provisions of deposit will apply. All the protections that we are doing is for the second charge holder onwards. Anyone who is first or on the pari passu right, that is the same equal footing as first charge holder, is not a deposit. Concept clear? Yes or no? So any amount raised by bonds, debentures secured by first charge is not a deposit. Anyone who is coming below the first charge holder will be a deposit. And the assets that we are securing are what all assets can you keep as security is given in Schedule 3. They say that tangible property should be kept, and therefore we are not going to count intangible property. So Schedule 3 says what all properties can be kept as security. So it is movable, immovable property can be kept as security. Intangible property like software, rights cannot be kept, goodwill cannot be kept as security. Clear? Then next, any amount raised by way of non-convertible debentures not constituting a charge on the assets of the company. So these are not constituting a charge. That means they are secured or unsecured. Quickly. So these are unsecured debentures. They are not secured. Okay. So we will say, oh, if it is not secured by first charge or they are not secured at all, they are deposits. But they are listed. So then they say listed company, they will pay the money, no problem. So listed secured debentures are not deposits. Are not deposits. Clear? Listed unsecured debentures are not deposits. SEBI is there to protect them. Listed company has a lot of money. Any amount received from employees not exceeding their annual salary, okay, under the contract of employment in the nature of non-interest bearing security is also not a deposit. What does this mean? Sometimes employees को क्या बोलते हैं हम लोग? What do we tell the employees that I am going to train you. You deposit at least 1 lakh rupees with us, so that if you leave the company within the time frame, within XYZ period, then we will forfeit that amount. Okay, so they keep it as a deposit. On this, you are not going to get any interest. So this they say that any amount received from an employee under an employment contract, not a very big amount, it is not exceeding his annual salary. Then we are saying छोटा amount है 10-20 हजार रखा होगा, small amount, it is not a deposit. But if it is exceeding the annual salary, it will be treated as deposit. Any non-interest bearing amount received held in trust. So any amount that we have received as a trust, who we have to return it back, is not a deposit. And it is not interest bearing, right? So obviously it will not be a deposit. Any amount received in the course of or in the business as an advance. Now always remember that advance received, okay, for goods, service or performance, okay, for performance guarantee is not deposit, is not deposits. What does it mean? Imagine if someone, I'm going to, let's say there is my company is here. My company is the supplier and there is a customer. There is a customer who is telling me that I want goods and services. Mujhe goods do. So what happens? The customer, that is the buyer, will say I want to buy. You start manufacturing. I say give me some advance so I will start. So this guy gives a advance payment. And this advance payment is for what? That you supply the goods, service, or we will perform whatever kind of nature of agreement is there. I will do the work. मुझे आप advance दो. Normally as lawyers, as company secretary, we tell the client to give advance. Then only we will start the money. This is called as initiation fee. If you want me to start the work, give me some advance. Can this advance be treated as a deposit and all the provisions of deposit? They say no. As long as we have supplied the good service or we have given the performance, then it is not a deposit. Clear? Now they'll give you scenarios where you're not doing, then it will be treated as a deposit. See, any amount received in the course or for the purpose of a business, okay, as an advance for supply of goods, service or for any performance, and that advance has been, against that advance the goods have been supplied within a period of 365 days, then it is not a deposit. So within 1 year if you've given the goods and service, then it is not a deposit. Any advance or any security deposit, any advance received, any advance received, any advance received, again and again they'll say advance received. For what? In connection with immovable property. So if I'm buying immovable property, I'm given the token amount. This token amount is also not a deposit. Advance for performance of contract. I give the advance, I say please come and perform. I'm giving you the money. So it's like a advance payment. All this is not a deposit. Any advance received for long-term projects. So I have given an advance. So you supply goods, service, anything. So that is not a deposit because it's a simple purchase and sale transaction. Advance received for providing future services. Okay, any advance allowed by sectorial regulators, any advance for subscription for any publication. Okay, so I have subscribed, for example, newspaper. So let's say there is Times of India. Times of India takes advance of the entire year for publications. Certain magazines, they take advance. So all of that is not a deposit. Now again, another important thing is promoters. Now again, when promoters are getting money, directors are getting money, we don't care. That's fine, it is not a deposit. And promoters are being arm twisted to get money and put into the company by the lending companies forcing them. अभी समझते हैं क्या? मतलब क्या? Will you as HDFC Bank give loan to anyone? Will you as a bank give loan to anyone? You can put a condition that tell the founders also to invest money. And so what happens is we will match the loan. There is a provision where they say we will match the loan amount. Means if the promoter, sometimes they say if the promoter gets 2 CR loan, then HDFC Bank will also give 2 CR loan. Okay, or if this, or if the promoter is getting 3 CR loan, then HDFC Bank is also ready to give 3 CR loan. Now sometimes why do they do? The creditors will put a condition on the promoters to ensure that their risk is divided and the promoters take serious steps to repay the loan and to make the company successful. So as a requirement order of the creditor to get the loan, see, the promoters are getting, so it is not a deposit. See, an amount brought by the promoters of the company by way of unsecured loan. Why? As in pursuance of a stipulation of an lending financial institution. As a in pursuance means because of the condition of a lending financial institution. Stipulation means request or condition of the lending financial institution. The promoters have got the money, then that amount is not a loan. That amount is not a deposit. For fulfillment of the following conditions, the loan is brought. The loan is provided by the promoters, and it is only till the financial institution is bank is repaid. If it is repaid, the loan, the financial institution gone, so the loan also should be repaid to the promoter. So simple, the promoter brings in loan with the bank and will exit with the bank. Any amount accepted by Nidhi company. Nidhi company's job is like a financial institution to accept deposits under section 406. Okay, so they will not come under the provisions of deposits. Any amount received by way of subscription. Obviously subscription to shares, subscription to any fund, chit fund is not a deposit. Subscription, any amount received by the company under collective investment scheme. Now CIS scheme is like a mutual fund. They receive units, they receive funds, against that they issue units. We have separate SEBI laws for it. So therefore this will not apply deposit provisions because they have separate laws for it. Now any amount of, now this is very important, okay, this is important, okay, super important. Let's see. Startup company. First you should know what is a startup company and then you should know what is a convertible note. Startup company and a convertible note. Nowadays it is the age of startups. Okay, it is the age of startups. So these convertible notes comes in. See, there is a startup. We see startup, Shark Tank India, Shark Tanks, etc. Okay, so there is a startup and there would be investors. Now these investors invest funds, inject fund into the startup, and in return they will issue some security. some shares, some debentures, something. Here they are saying startups are eligible to issue something called as a convertible note. Convertible note. This convertible note is a special type of security, or like how we have shares, debentures. This is a special type of convertible note used specifically only for startups. Now from the name itself, it's a convertible note. Means what? It is a debt instrument, debenture, which can be converted into shares of the startup. Clear? These are debt which can be converted into the shares of the startup. Let's see, or let's read the provision. There is a amendment also, and you should know the amendment. And I feel this can come in your exam. Any amount of 25 lakh rupees or more received by the startup, 25 lakhs or more received by the startup by way of a convertible note within a period not exceeding 10 years. Now, as per the 2020 amendment, the 5 years here has been increased to 10 years. Earlier, the limit was 5 years. If you have anywhere reading 5 years, change it. It has been amended and now it is put 10 years. So, any amount of rupees 25 lakhs or more that has been invested in the startups, and it is convertible into equity shares. Convertible note means convertible into equity shares within a period not exceeding 10 years. So what is the amount here? So the amount is 25 lakhs or more has been invested in the startup, and it can be converted into, so it is convertible within 10 years. Earlier the limit was 5 years. Now they've said, okay, fine, within 10 years also you can convert it into the shares of the startup company. Clear till here? Now they've explained what is the meaning of convertible note, and they've also explained what is the meaning of startup. Both they have explained and I have already explained. Startup means a private company. So a public company cannot be called as a startup. Private company which has been recognized, okay, as per the notification given as issued by the DIPP, okay. So they have been recognized as, so not every private company which has just started is a startup. It has to be recognized by the Department of Industrial Promotion and Policy, Ministry of Commerce and Industry. And what do you mean by a convertible note? Means an instrument evidencing receipt of money initially as a debt, which is repayable at the option of the holder, which is convertible into the shares of the startup company. Clear? And last, any amount received by the company from the AIF, Domestic Venture Capital Fund, all of them, if I am a amount received by AIFs, domestic funds, mutual funds, REITs, infrastructure investment trust, all have dedicated provisions. So these are all not deposits. We've seen if there is a CIS, collective investment scheme, or a mutual fund, or a AIF fund, or a chit fund, okay, or they've given you which other funds? Domestic venture capital funds, then they've given you venture capital funds, REITs, real estate, the infrastructure investment trust. All these receive money from investors. They receive money from investors and then they invest. Okay, they receive funds from investors and then they invest. Now for all these there are dedicated provisions and dedicated rules, regulations and criteria, conditions for it. So all of them will not fall under section 73 to 76A. Condition need not be followed, don't have to be followed since they are not deposits. Clear till here? So we've completed a very important part, that is the definition of deposits. What are and what are not deposits. Okay, now we'll just go through this illustration really quick. If you've just gone through the earlier ones, you will be able to answer this. Now I just want me to I want you all to tell me whether it is a deposit or no. Okay, from here. First, rupees 5 crores received from government agency. Deposit by way of commercial paper. Deposit or not deposit? Not a deposit. By way 50 lakh rupees received by share subscription money. So it is not a deposit, provided within 60 days and additional 15 days, that is total of 75 days, the amount is refunded or shares are allotted. Where 50 lakh rupees has been 50 lakh rupees is from one of his directors for loan. So obviously it is not a deposit, provided the director gives in writing that he has not borrowed from anyone else. Issue of bonds and debentures. So are bonds and debentures deposits? Answer is no. If they are secured by first charge, they are not. If they are not secured by first charge, then they will be treated as deposits. Inter-corporate deposits are not covered and are not deposits. Rupees 25 lakh rupees from its employees. So this is also not a deposit as long as you have taken it under an employment contract and it is not more than his annual salary. Then comes rupees 50 lakh rupees as a business advance from customers. Advance has completely been out of the purview of deposits. Advance receive against consideration for immovable property. So if you are giving immovable property, against that you've got an advance, it is not deposits. So you have to mention with the condition as we have read. Okay, so write section 2 subsection 31, write rule 21C. Then they tell rupees 25 lakh rupees as a security deposit for performance of a service. Now deposits completely outside the purview. It is a normal sale transaction. Rupees 50 lakhs from its promoters as a condition by the bank that we will match the borrowings. You get how much ever, we will give that much loan. You give X loan, we will also give X loan. Okay, so then the promoter amount will not be treated as a deposit because it is on a stipulation by the lending bank. Next is rupees 25 lakhs raised by issue of non-convertible debentures. They are not securing charge on the assets of the company. Now these are non-convertible debentures. Now pay attention. If these are NCDs, non-convertible debentures, if they are listed, then they are not deposits. Clear till here? So we've covered all of this. Then I had explained you rule 21C. Now we are doing rule 21D. What does rule 21D talk about? 21D is depositor. Who is a depositor? A person who makes a deposit with the company. Simple, जो पैसा दे रहा है वो deposit. So anyone who has given a deposit with the company is a depositor. A person who has made a deposit with the company is a depositor. Clear? They've given you section 23, 73 and 76. Here this is deposits from public. This is deposits from other than public. Okay, that is why they are saying that who is a depositor? If under anyone who has deposited under section 73 or under section 76 is a depositor. Now I told you 21C we did, 21D we did, and now we are doing rule 21E. Okay, let's see. What do you mean by eligible company? So eligible companies are eligible to raise deposits from public. Clear till here? Only eligible company is eligible to raise deposits from public. Now what was the logic behind? See, public company, should they be allowed to tap public, raise money from public? You tell me. You will obviously say, yeah, what is the problem? Now, the problem was when you read the Sahara Housing Finance Corporation scam where Subrata Roy went in jail. They started realizing that companies, public companies, which have just set up as a public company, you can set up a public company with 7 or more people, but they don't even have that much net worth. Why we should allow them to raise money from public? They don't have net worth, they don't have paid up money in the company. Just because they have 7 or more people have set up the company as a public company, will you authorize them to go and take loans from the public? So then they said, no, we don't want public to go. We want only good public companies. Only eligible public company can raise deposits, from public. Concept clear? So eligible means they are good. Good public companies who have a certain net worth, turnover, paid up capital, we'll see what are the limits, only they can tap the public. So under section 76, it says raising of deposits from public, only eligible companies are allowed. Now we will see the definition of eligible company. Clear till here? Eligible company means a public company which having a net worth of 100 crores and a turnover of 500 crores, who has obtained prior consent in the meeting by a special resolution and has also filed the necessary documents with the ROC. Let's read. So market is important. Now eligible is when they have the turnover. It's a public company. Eligible company means a public company. See here, they again means a public company. Okay, having a net worth and or having a turnover. So it is a public company having a turnover of 500 crores or more, or a net worth of 100 crores or more, and who has obtained a consent from the shareholders by way of special resolution. They can raise money from public. Concept clear? Eligible company, you should know, I will be using these terms when I move ahead. Even in section 76, I will be using eligible company. You should remember the term 100 CR and 500 crores. 100 CR net worth and 500 crore turnover. Either of these conditions they have met and they have taken special resolution, they are eligible to tap the reach out and raise money from the public. However, an eligible company, while accepting deposits within the limits of section 81C, we saw, may accept deposits by ordinary resolution. See, so if it is within the limits, okay, so if it is within limits of, if the loan or the borrowing is within limit of 180, yes or no? What is the situation? Is the loan, is borrowing within the limits of section 180? If yes, then you require ordinary resolution. If no, then they require special resolution. Concept clear? Okay, if they want to go beyond the 100% of paid up capital plus free reserve plus security premium account, such a big amount loan, then take a special resolution. Within that limit, ordinary resolution is allowed and you can raise the money. Clear till here? Let's move ahead. Prohibition. Now we are doing section 73, 74, 75, 76, 76A. 75 talks about prohibition on acceptance of deposits. Section 73 says that no company shall invite, accept or renew any deposits from public except in the manner provided under chapter 5. So 73 subsection 1 saying that you have to comply with the provision, only then you can raise, invite and accept deposits. Now we'll be seeing chapter 5, what are the conditions everywhere. See, applicability. Section 73 to 76 shall not apply to all these companies. Tell me why. Banking company, non-banking finance company, housing company, any other which the central government has done, they have to read with rule 2.1, rule 1, sub rule 3 gives you the applicability. Why are banking companies shall apply to all companies except, means these are the provision do not apply. So section 73 to 76A do not apply to them, deposit provision. Why? Because they have already a license to accept deposits, right? So the deposit provision will not apply. Banking company, you make FD, na? You make FD or no? That is not a deposit under 73 to 76A. NBFC is also same. Housing finance company also, they take deposits and then they give loans. So this is their job. For them, it is not applicable. It is for other companies. Reliance Industries wants to raise money and borrow from public. Then section 7 deposit chapter will apply. Clear till here? So the following companies logically are exempted from the provisions of 73 to 76A for deposits. Clear? Because that's their normal job. Now coming to acceptance of deposits. Now understand one thing. What did I tell you? Only eligible companies can accept deposits from public. Only eligible companies can raise money from public. What is the limit given? Who are eligible companies? So these are public companies who have a net worth and turnover. Can you all tell me what is a net worth and turnover? The limit that they have given. Net worth and turnover. How much was it? Net worth and turnover quickly. So very good. It was 100 and 500. See here we've written 100 and 500. So net worth of 100 crores or more and turnover of 500 crores or more. Clear? Now apart from them, that is private companies or public companies who are below the net worth and turnover. So can they raise money? Obviously even they can raise money, but not from public but from members. So private companies can also accept deposits from its own members, and public companies other than those who don't have the net worth and the turnover, they can also raise money from deposit, but not from public but from their own members. So we can say who can raise deposits. Okay, so very simple. If it is a eligible company, they can raise from public, and those who are other companies cannot raise from public, they can go from only members. Concept clear? Eligible company can raise from members as well as public, and whereas other companies other than eligible can only go from members. Let's see. And there are certain form numbers that you will have to remember. Just take a screenshot or write it down, pause and write it down. Now I'll tell you in short what are these. Then while doing the chapter I will put these forms also. First, if my company is there and my company wants to raise money, I want to borrow money in the form of deposits. So I will have to give a prospectus, right? I have to give a prospectus telling people come subscribe to my deposits. मुझे बताना पड़ेगा ना कि मेरे deposit subscribe करो, please subscribe to my deposits. बोलना पड़ेगा कि नहीं? So here they are not calling it as prospectus, they are calling it as a circular inviting deposits. Circular inviting deposits. It's nothing but a prospectus. It will be in a form called as DPT1. This circular has to be given 30 days before circulating to the public, to the ROC. 30 days before issuing it to public or issuing it to anyone, I have to show it to ROC first. Then to protect the the depositors. So let's say these are the depositors. They are these are many depositors. to protect the depositors. They don't have day-to-day rights. They don't have that much expertise. For them, we appoint someone called as a deposit trustee. We appoint someone called as a deposit trustee. Deposit trustee. Okay. The job of a deposit trustee is to protect the interest of the depositors. So he will protect interest of depositors. He will see that there is no default. He will see that the security is properly charged. He will see that it is properly insured. If there is any default, he will emergency call a meeting. He will file cases in NCLT, etc. So the deposit trustee is appointed. Just like in debentures, we have debenture trustee. Now to appoint this debenture trustee, we have to enter into an agreement with him. Yes or no? A trust deed. The trust deed will have to be entered. This trust deed will be in form DPT2. Clear? So we appoint the trustee to protect the interests of depositors through the trust deed. The appointment letter is called as a trust deed. It will contain the details of his duties, his remuneration, his rights, his liabilities, his removal. He should not be connected with the company. He should work for the interest of depositors. All of that will be given. Then every year the company has to give details of their deposits. The information regarding deposits has to be given to ROC every year. Every year it will have to be given. This is going to be in DPT3, and DPT4 is now become invalid because when the Companies Act has passed, and that time whichever deposits were existing at the time when Companies Act 2013 was passed, so they have to give that, listen, I'm in 2013, my deposits are still pending. Do I have to follow 1956 Act or do I have to follow 2013 Act? So it was a transitional provision. So they have to say the existing at the time when Companies Act was passed, commenced. So they have to give in DPT4. Now this has no value or worth. So DPT1, prospectus, offer, circular inviting deposits. DPT2, trust deed. DPT3, returns. Now we will see the deposit chapter. Okay. Now conditions for accepting deposits from members. Now this section 73 subsection 2 gives you certain conditions to be fulfilled if you want to accept deposits from members. So again, understand, if you want to take deposits from members, or you want to take from public. If you want to take deposits from public, then you have to follow section 76. And if you are taking from members, you have to follow section 73 subsection 2. The conditions given in section 73 subsection 2 has to be followed. Clear till here? Now, let's see. What are the conditions? First, simple resolution has to be taken. Ordinary resolution has to be taken. Passing of resolution. For raising with public, we had seen beyond that limit, then you have to take special resolution. This is raising from members, ordinary resolution is fine. Then in consultation with RBI, accept the deposits from its members subject to the following conditions. Now what are the conditions? A circular has to be given. The circular will contain all the details of the deposits, the how much rating this company has got, how total number of depositors that are there, how much is the amount due, okay, the financial position of the company. As you see ना prospectus में जो detail होता है यही circular में होगा. Members को बताएंगे कि ये सब details है, आपके पास से इतना पैसा ले रहे. तो the circular will contain all the basic details of the deposit. This will be in DPT 1 as we just discussed. this DPT1 has to be given to the ROC before circulating it. 30 days before circulating the this have to give it to the ROC. Filing of the circular with the ROC within 30 days before the date of circular of the issue of the circular. Clear? So if I am issue of DPT1 is here, 30 days prior I have to submit it to ROC. Concept clear? So 30 days prior to issue of DPT, it has to be given to the ROC. Common sense. First ROC will check, then only I will issue to people. Then one interesting thing is there, to protect the depositors, they say that you make a deposit repayment reserve. Deposit repayment reserve is to be created. What is it? Let's understand. Depositing on or before 30th April each year a sum which shall not be less than 20% of the deposit maturing during the next year, following year, and it should be kept in a separate bank account. Very, very simple. DRR. Just like we have in debentures redemption reserve, here you have a deposit repayment reserve. So let's understand what is this. It's like this is a reserve that you will create where you will every year you have to deposit some amount, okay, into this to repay. Deposit repayment reserve. In this reserve should be used only for repayment of the deposit holders. You cannot, it is a statutory reserve, you cannot use for any other purpose. So it is to protect deposit holders. Yes or no? So that if there is some amount, they will be secured. Yes, we have so much amount, only balance amount we have to remove. Now when you have to do, moment the financial year starts on 1st April. By 30th April, I have to put minimum 20% of the deposits that will mature next year, of deposits maturing in the following year. Okay, so I will see how much deposits are maturing next year. Of that, 20% I have to keep now only, and that too from 1st April, that is moment the year starts. Let's read again. Deposit on or before 30th each year a sum which shall not be less than 20% of the amounts in its deposits maturing during the following, that is the next year, and kept in a separate bank account called as deposit repayment reserve. Then also a certificate saying that they have not committed any default in repayment of the deposits, okay, or in payment of any interest. And this is very interesting. And where a default has occurred, मतलब मैं deposit उठा रहा हूँ, I am taking loans from people, so I will have to tell them that listen, I have not defaulted anyone, relax, okay, everything is going properly. Or a case where I have defaulted, then I will still say relax, I have made good the default, I have paid off. मैंने default किया था, I had made a default, but I made good, I paid it off. Now there is no default existing, but there is a cooling period, and a period of 5 years has elapsed from the date of making the good the default. So I get 5 years ban from raising deposits again if I have defaulted. So if a company has defaulted, then they have to wait for 5 years after they have rectified their default. Only then they can raise the money as deposit. Next, providing security. So if it is, so in the deposits you will have to mention clearly whether it is secured deposits or it is unsecured. See, in secured also it should have a 100% asset cover, 100% asset cover. means the amount of loan that I'm taking, I'm borrowing, full amount should be secured by assets. That means if there is a default, I will be able to pay off the asset and give them the amount. So it should be secured. So then secured by proper assets so that it will be sufficient to sell the assets and repay the loan. And unsecured, if it is unsecured loans, deposits can also be taken. Obviously it's very risky. So you have to mention it clearly that it is unsecured. See here, where a company does not issue secured deposits, then the deposit shall be termed as unsecured and quoted in every circular, form, advertisement, everywhere, so that everyone sees that it is unsecured clearly. Next is a amendment which has now come in, okay, which is very, very, very important. Even practically we have got this doubts. Super important amendment. What is it? Now private companies have got exemptions. Now we saw all the above things, they were there. Then an exemption notification was issued. MCA wide a notification on 2015 and 2017 gave exemption to private companies where they do not have to comply with A to E. Section 72 A to E, they don't have to comply. Private companies. So they are very happy. See, A to E, they don't have to comply. Circular, 30 days prior, DRR, default, all of these they don't have to comply. Clear till here? If any of the conditions are fulfilled. So chapter 5, section 73, subsection 2, A to E does not apply to private companies. Okay, so this is important. If any of the conditions are fulfilled. So private companies have been given relaxation if they fulfill these conditions. Now what are the conditions? Very important. Not all private companies it is exempt. You have to fulfill conditions. Let's see. Private company accepts from its members not exceeding 100% of its paid up capital plus free reserve plus security premium account. So they don't have to take all this consent and inform ROC in DPT1, all those things they don't have to do if they are taking a loan not beyond, not exceeding paid up capital plus free reserve plus security premium account. So we say fine, itna to they will be able to repay because they have paid up capital, free reserves and security premium account. Or they have the private company is a startup for 5 years from the date of its incorporation. Okay, so private company is a startup for 5 years from the date of incorporation. So during the 5 years they do, and they have within the 5 years they don't have to worry. Private company which is a startup for 5 years from the date of incorporation, such startup can raise deposits without complying with A to E points. So minimum 5 years of existence they are there as a startup. Private company which fulfills the following conditions. So more conditions they have given, fulfills the following conditions. It is not an associate subsidiary of any other company. If the borrowing of such company is from banks is less than twice of the paid up capital of 50 crores, whichever is lower, and such company is not defaulted of such borrowing subsisting at the time of deposits under this section. So again, private companies, 3 categories do not require. First category is they are within the limits. Second category, they are startups and 5 years are elapsed from their incorporation. And third condition they've given, you are not an associate. Okay, if the borrowing of such company from banks is less than twice of the paid up capital or 50 crores, whichever is lower. So the loan that they've already taken is less, okay, than 50 crores or twice of the paid up capital, less than twice of the paid up capital. 2x of paid up capital, whichever is lower, they've taken a loan below this. So the private company do not have to follow. So if we see reverse, If a company which has taken more than this, a private company which has taken more, they will have to comply. A private company which is a startup and just they have formed and they want to take, they will have to comply with all the conditions. And a private company which wants to accept more than 100% of paid up capital plus free reserve plus security premium, then they will have to follow the conditions. All others they will not have to follow. Clear? Provided that the companies referred under ABC shall file the details of the money accepted to the registrar in the specified form. So they don't require approvals, but they have to give details of the loans taken. Clear? Now we're talking, so private companies have got exemptions from section 73 subsection 2 subclause A to E. Now there is other class of public companies which have also been exempted from the same points. They are public IFSC company. What is a IFSC? International Financial Service Centers. Now what are these International Financial Service Centers? These are in India and serving foreigners. So their clients are foreigners only, but they want to be located in India. Like for example, we see a call center, right? A call center is in India, but obviously they are catering customers outside India. Same way a financial service center has been in India and they are giving financial services to persons outside the jurisdiction of the domestic economy of outside India. So then these companies also, we want such foreign companies to set up in India, so we give them exemption. Now see, they don't affect us at all. All they do is they help us employment, they help us taking place, they give taxes to the India. So it is good for us and the customers are not us. So it's fine. So it will not apply to them, to a specified public financial which accept deposits from its money from its members. Money is not exceeding 100% of the paid up capital plus free reserves. And such company shall file the details so accepted with the registrar. So that details has to be given. Repayment of deposits. Now obviously now we did subsection 1, 73 subsection 1, 73 subsection 2. Now we're doing 73 subsection 3, which says very simple. Every deposit accepted shall be repaid with interest in accordance with the terms of the conditions of the agreement. ठीक है, जैसा condition के हिसाब से repay कर देंगे. Now we'll repay as per the conditions. Next is failure on repayment of deposits. Failure on repayment of deposits. If there is a failure, imagine you were a depositor and the company failed to repay you. What you will do? Will you cry? Will you feel sad? Or you will go to tribunal under class suits and file and recover the money? So the answer is, there is a failure where a company fails to repay. The depositor may apply to the tribunal for an order directing the company to pay the sum or any loss or damage that they have caused. This is given in 73 subsection 4. Now let's see subsection 5. What do they talk about? They talk about the reserve, repayment reserve. So we've seen as per subsection 2C that a reserve has to be made and it should be used only for the purpose and for repaying depositors and for no other purpose. So the deposit repayment reserve shall not be used by the company for any purpose other than repayment of deposits. Clear till here? Common sense. So we are done with section 73. Section 73 talks about conditions for deposits from members. Clear? 73 subsection 1, subsection 2, we've seen entirely with the clauses. Then we've also seen till all the subsections, that is subsection 4, 5 and have also we have seen. Okay, so 5 subsections we've seen. You better note it down so you can quote it with the sections. Clear? So all 5 subsections we have done. So subsection 1, 2, 3, 4, 5. So I want you to write down all the 5 subsections, what it is related to, and this is the most important. the conditions. Clear? Now coming to deposits accepted before commencement of the act. Now when the Companies Act 2013 was passed, it was possible that there were certain deposits already existing under the previous law. Under the previous law, 1956 Act, it was section 58 of 1956 Act. So if deposits were raised under section 58 of 1956 and now 1956 got repealed and new act came and those deposits are still existing, so they have got 3 months time to transit and file a document with the ROC and tell that now we will come under the Companies Act 2013. So that form will be in DPT 4, that intimation that listen, we are still existing, our act got repealed and 2013 act is there. So DPT 4 will have to be filed with ROC. When in respect of deposits accepted by the company before the commencement of this act 2013, the amounts of such deposits or a part thereof or interest thereon remains unpaid, there is some pending amount, then you have to file with ROC within 3 months from the commencement of Companies Act TPT 4 and repay the entire amount within 3 years. That is 13, 14, 15, 16. You have to repay it. Clear? Then now we've done section 73, 74 was small and we have done DPT 4. Now comes 75. 75 talks about section damages for fraud. If any deposits were taken with the intention to defraud the depositors, अगर कोई भी तुमने गलत तरीके से लिया, if you've taken money, borrowed money with the intention to defraud people, then the liability is given that they will be liable, every company secretary will be held liable, every person responsible will be liable without any limitation on their liability. जितना भी loss है सब repay करना पड़ेगा. So when a company fails to repay the deposits or any interest thereon, okay, you have not repaid the deposit principal amount or the interest thereon, then and it is proved that the deposits has been accepted with the intention to defraud the depositors or for any fraudulent purpose, every officer who is responsible for acceptance shall be liable without any liability. Any suit, proceedings, other actions taken by any person or group of persons, okay, who had incurred any loss as a result of the failure to repay therein, state that any suits may be undertaken by any person who has faced the loss due to the fraud. So 51 says that if anyone has proved that the deposits were accepted with the intention to defraud, then the liability of the officers in default will be unlimited and the suit can be brought in by any person who had incurred loss. Clear? Section 75. Now we are coming to the most important section after section 73 subsection 2. It is your section 76. Section 76 talks about acceptance of deposits. Now section 76 talks about acceptance of deposits from public. Okay. Now who is allowed to take from public? Please tell me. Obviously eligible companies. Who are eligible companies? They have a net worth of 100 crores and turnover of 500 crores. They can accept from persons other than its member. That means public. Such company shall be required to obtain certain credit ratings. Okay. And that rating has to be informed to the public. That rating will be a what? Rating will be of the company's financial position, their net worth, their liquidity, their ability to repay the deposit. Someone should, even if less rating is there, some people like to invest in risky businesses. It is like buying lottery for them. It is available on a low price and risk is also. Normally good credit rating companies are there. People invest in that. Every company accepting secured deposits from public shall within 30 days of the acceptance create a charge on their assets. So moment you accepted secured deposits, then within 30 days of the acceptance, create a charge on its assets, okay, of an amount not less than the amount of the deposits accepted. मतलब 100% asset cover. 100% asset cover means what? How much ever is the deposit, that much amount of asset should be charged, value. And all the other provisions shall apply mutatis mutandis unless otherwise stated. Then comes the rules. Okay, from rules, I will tell you which is important, though I will do everything, but I'll tell you which is important from exam point of view. The Companies Accepting Deposit Rules 2014. First, the time limit. Deposits can be issued for how much time period? So the answer is 6 months to 36 months. The tenure of the deposits, no eligible company or no company given under 73 subsection 2 or section 76 shall accept deposits within a period of 6 months. So before 6 months, cannot issue a deposit for 2 months, 1 month, 2 days. It should be minimum 6 months and maximum 36 months. So I cannot have a deposit under 73 to 76 for 4 years, 5 years, no. One exception is given, that if it is a short-term deposit, still we are giving, instead of 3 months we are giving it, okay fine, short-term we are allowing of a certain amount but not earlier than 3 months. So for short-term deposits they are saying you can take a deposit but not greater, short-term loan should not be taken exceeding 10% of paid up capital plus free reserves plus security premium account. So max of this much amount, and that too minimum should be 3 months, not earlier than 3 months. 6 months was the normal time limit. In short term you can reduce it to 3 months but not lesser than 3 months. A company may, for the purpose of meeting any of its short term requirement of funds, may accept or renew any such deposits earlier than 6 months also, on the condition that such deposits shall not exceed 10% of the paid up capital plus free reserve plus security premium, and such deposits are not repayable earlier than 3 months. Concept clear? Next, joint names. Obviously, if there are 2 people who are investing, so the names can come jointly, as we have joint owners of houses, we have joint owners of shares, we can also have joint owners of depositors. Now jointly can be given either or, survivor, first name or survivor, anyone or survivor. So when the depositors desire, the deposits may be accepted in joint name, not exceeding 3 or so max number of joint names you can have is max 3. Okay, and they can name it jointly, either or. So if those rights are to sell, okay, if you want to sell, so either or survivor, anyone or survivor, so all these terms can be there. Then comes acceptance limit for deposit. Now very, very important, acceptance limit. Now what do you mean by acceptance limit of deposits? If a company that they can take unlimited deposits, unlimited deposit, paid up capital plus free reserve plus security premium is 1 crore. Can I take loan of 10 crores? Then how much can I take? So they have divided it. Okay, I will show you the direct structure only here. You can mark this as important. Quantum of deposits in a nutshell. This is the quantum of deposits that you can take. Now eligible company, how much they can take from members, how much they can take from public. Whatever calculation we are going to do is a percentage of paid up capital plus free reserves plus security premium account. Clear till here? So eligible company can take up to 10% of paid up capital plus free reserve plus security premium account. I'll call it as X. Eligible company from public, how much they can take? Up to 25% of X. Other than public company, so it could be a private company or it could be a public company which is not having the net worth or turnover. So it is a small public company. So companies referred under section 73 subsection 2, they can only raise from members that to up to 35% of X. From public, obviously they are not allowed to go because only eligible company can go to public. Then the third category is for government companies. Now government is only the member, so they are saying don't take from government. They will, so it's obviously it's a government company. Government is holding shares. Government are the members. So government giving deposits? No. Government is allowed to go to tap public up to maximum limit. You see, 35% of paid up capital plus free reserves, security premium account. Clear? So government can raise maximum amount from public. Eligible companies can raise 25%. From members, eligible companies can raise 10%. And your members, from members you can raise, non-eligible company can raise up to 35% from members. Clear? So now we'll quickly read. Always remember, DPT 3 will have to be filed. Okay, so these are return of deposit. Return of deposit. Return means what? What do you mean by return of deposits? Can anyone put and tell me? Return means, simple word, details of deposits has to be filed by everyone. So they will use a reference. We saw in the form also. So here I'll go fast now. Acceptance of deposits from its members shall not exceed 35% of all this. They have to file DPT 3. Next, again we've seen that startup companies have been given exemption. Okay, and a specified IFSC, that is your International Financial Service Centers, public companies and private companies may accept from its members not exceeding this much amount, and the details they will give it in DPT 3. The provided further that the maximum limit accepted from members shall not apply in the following cases of private companies. Now, very important, understand. The quantum of deposits for public companies is what, private companies, what I'm going to teach you now. See, the table I showed you, but nowhere they had mentioned for private company what is the criteria given. Okay, private companies who are startups, etc., what is the benefit? Pay attention. They are saying that a specified IFSC company and a private company may accept from its members 100% of its paid up capital plus free reserves and security premium account, and they will file the details in DPT 3. Concept clear? Is there any difficulty from here? That all this limit we saw, but a private company, because so a public unlisted company doesn't have, for them the limits are there. For private company a separate notification is there, that is why it is not covered here. See, this is the normal limit given here. For private company there is a separate notification given which I am reading now. So pay attention, they can raise 100%. See, so I can write it here only. This is the quantum for private company. How much they can raise? 100% of paid up capital plus free reserves plus security premium account. Concept clear? So this is the one more table they should add. If you read with the notification, you read with the exemption notification, they can raise up till this limit. Clear? This we have given advice also, so that is why I can tell you how important it is. Exception that a private company may accept from its members money not exceeding 100% of paid up capital plus free reserves plus security premium account, and such details shall be given in DPT 3. Now, what happened is, if further the private company can fulfill certain more conditions, they can even exceed this limit. More than 100% also private company can raise. When? I'll read. See, provided further means the maximum limit shall not apply to the following classes of private companies. So provided further means, listen, further the maximum limit in respect of deposits to be accepted from members shall not apply in the following classes of companies. Means these companies can raise deposits more than 100% of paid up capital plus free reserves plus security premium account also. Clear? Now what are the conditions here? If the private company which is a startup for 10 years from the date of its incorporation, okay, earlier it was 5, just write it 10 years. A private company which fulfills any of the following condition. So a startup can raise more than 100% also. A private company which fulfills all of the following conditions. It is not an associate subsidiary of any other company. The borrowing of such company from banks is less than twice of the paid up capital. So whatever is the paid up capital of the company, the borrowings from other banks is less than 2x. See, the borrowing of such company from banks is less. So borrowing from banks, what they have done is less than twice of the paid up capital. So this is less than, so their current borrowings is less than twice of the paid up capital plus free reserves, or 50 crore rupees, whichever is less, and they have not defaulted in such borrowing subsisting at the time of deposits under section 73. So two things they have given. Let's see. So what is the answer? That private companies can borrow, take deposits up till 100% of paid up capital plus free reserves plus security premium account. Okay. Now the following two companies, the following two sets of companies can raise deposits beyond maximum limit, beyond max limit. This is the max limit. Private company can raise, this is the maximum limit. Now they've given that the following classes of companies can raise even beyond the maximum limit. What is the condition? First, it is a startup company. Just make the correction that it is a startup company in existence for 10 years. Then they can raise beyond this limit also. And second, few other conditions have been given, that it is not a subsidiary of any other company, associate of any other company. Second is they have not done any default on their current loans that they've already taken. And third, they are saying that the loans that they have taken is less than 2x, twice of the paid up capital, this, or 50 crores, whichever is less. Clear? For example, if a private company, okay, a private company has already taken loan of 20 crores only, then obviously they can go beyond the limit also. Clear? But they have to ensure that they do not exceed this limit. Clear? So not very important for you now, but you should know. So private companies, this is the limit. Then they can exceed limit if they can exceed limit if two conditions are fulfilled. Now coming to the next one. No eligible company shall accept or renew any of its deposits from its members exceeds 10%. So same way as we read the threshold limits, eligible company from members is 10% and from others it is 25%. Government companies can raise up till 35%. So keep this limits in mind. Clear? So here they have given maximum limit in respect of deposits. Eligible companies can raise 25%, from public and from members 10%. Now when we see non-eligible companies, then from public they are prohibited to raise funds. From members they can raise up to 35%. Now exemptions for private company. Exemptions are given to two people only, private companies and IFSC companies. Both of them can raise up to 100% of the paid up capital, free reserves and security premium account. Now in private company, further they are saying that you can raise more than the 100% also if the following conditions are fulfilled. What is it? The maximum limit of deposits to be accepted from members shall not apply to the following classes of companies. A private company which is a startup for 10 years from the date of its incorporation, a private company which fulfills any of the following conditions, that is, it is not an associate subsidiary of another company, it has not defaulted, and the current borrowings is less than twice of the paid up capital. The current borrowings is less than the twice of the paid up capital, or 50 crores, whichever is less. Now coming to the rate of interest. Now obviously rate of interest, deposits, payment of brokerage. No company or eligible company shall invite deposits giving an interest rate which is exceeding the maximum rate as prescribed by RBI. Who is eligible to receive brokerage? Obviously, if the company gives brokerage, like you have your brokers, so they should be authorized by the company to solicit deposits. Matlab kya? Very simple. If my company is there, I can appoint certain bankers as my solicitors, certain persons as my brokers who will try to sell my security. So we go to banks. You've seen so many times they try to sell some securities to you. So it is possible that I might appoint them as my broker, and whatever sale they get it done through me, they will get brokerage. Alteration of terms and conditions. Obviously, you cannot alter the conditions to prejudice or put the depositors at disadvantage. Credit rating. Obviously, every eligible company shall obtain credit rating at least once a year. Okay, every year they have to keep getting the ratings, because the ratings can fall. Right, in 1 year you might be performing well, next year you might not be performing well. So every eligible company shall obtain at least once a year a credit rating and disclose that, and also inform to the ROC in their returns, in their details in DPT 3. The rating should not fall below the investment grade as fixed by RBI or any other authority. Now again, forms of advertisement. Now this is important. Rule 4. So remember I told you that I will tell you in this which is important. So you can quote rule 4 every time, because the form numbers will come here. DPT 1, it is the circular inviting deposits. Circular is issued to invite deposits, will be in DPT 1. The circular will be maybe published in English vernacular newspaper, so that people can come in. It's like your marketing. A certificate. Okay. A certificate of statutory auditor shall be attached that it has not committed any default. So auditors will have to certify, and that certification will be added to DPT 1 that there has not been any default. Then the DPT 1 stating that the company has made good the default and a period of 5 years has lapsed from the date of making good. So if the company has made a default, the auditors have said that they made the good default. Okay, then the DPT1 will also be put on the company's website. It can be published. So you can read it, not important. Just remember DPT1 related. No company shall issue or allow unless the circular is in the form in the name of the board of directors. So DPT1 will be in the name of the BOD. Does not less than 30 days before it has to be delivered to the ROC. Again important that DPT1 will be given and to the ROC 30 days before publication. Next is circular shall be valid until the expiry of 6 months. So if a circular is there and I have published it, that circular will have a validity. That means I will take the offers, close the offer, everything till 6 months from the date of closure of the financial year. So every circular that I issue, obviously it will have my ratings. It will have a validity period of 6 months from the closure of the financial year. After that period, if I want to raise money, then again I have to issue a fresh circular. Creation of security. So I told you that it can be secured also, secured by all the assets given in Schedule 3, but intangible assets should not be included. Okay, so in Schedule 3 you go to see it said you can give a movable property, immobile property. Intangible property cannot be kept. Then comes appointment of trustees. So remember I told you DPT2 has to be given at least 7 days before issuing of the circular for advertisement. So 30 days prior I have to give to ROC, 7 days prior I have to execute a trust deed. A trust deed has to be made. Okay, and no company or eligible company shall issue a circular unless they have appointed one or more trustees for taking care of the depositors. And a written consent also has to be taken. Then certain persons not to be appointed. So if you go to see that it's similar to debenture holder trustees disqualification. See, the trustees cannot be connected with the company, right? Otherwise they will favor the company, not the holders. So they should not be a director, KMP of the company. They should not be indebted to the company. They should not have any pecuniary relationship with the company. They should not have entered into a guarantee agreement with the company or any other thing where we feel that their connection is there with the company. Because if they have a connection prior, then they will tilt in favor of the company and not towards the deposit holders. So the trustee will work for the benefit of the holders. So they should not have any connection with the company. Now, removal of deposit trustees. Removal of deposit trustees. So with the consent of all the directors. So you can remove the trustee with consent of all the directors. And if there is an independent director, if the company is required to appoint independent directors, then at least one ID should be sitting at the meeting. Duties of the deposit trustee is same like duties of the debenture holder trustees. Okay, they will ensure that the assets are secured. They will ensure that there is no misstatement. They will ensure that the company does not commit any breach. They will ensure that the assets are secured. Okay, they will supervise the implementation. They will carry out such other things as is needed. Meetings of the depositors through deposit trustees. Okay, meeting of the depositors through deposit trustees. What does it mean? Now, meeting of depositors through trustees. Now, if the depositors are there and they feel that they want to call a EGM, a meeting of them, an extraordinary meeting of them. So they will give in writing, the requisition request will be given, signed by at least 1/10 of the depositors, or on happening of any event such as a default, the depositors will call an urgent meeting. They will tell the trustee to call the meeting. So all the depositors shall be called by the trustee for depositors on the meeting of all the depositors shall be called by the trustees on requisition or on happening of a default. Then nomination. You can the depositors have a right to nominate someone to whom these deposits will vest on their death. Furnishing of deposit receipts to the depositors. Now this is also very important. 21 days, remember, 21 days from the receipt of money. If someone has made a payment to you, would you issue a receipt? Yes or no? If someone has issued will you issue a receipt? Yes or no? Obviously, here also every company shall, on acceptance of a deposit. So let's say you have accepted a deposit, then you will furnish to the depositor. So if we have taken money within 21 days from the date of money realization, in case of check it has got deposit, so whenever it is there, we have realized we have to issue within 21 days to the depositor. So which all dates we were seeing? We were seeing 30 days prior you have to give ROC notice. 7 days prior we saw you will appoint the depositors. So DPT 2, 7 days prior to issuing. This is before issuing circular. 30 days prior I will give to ROC, the DPT 1, right? Then we've seen another date is deposit receipt. Deposit receipt has to be given 21 days from date of receipt of money. Date of receipt of money. Clear? And one more date was there. That was the DPT 3 date, which we will see now. Okay, when you have to make this return filing. Here. Now comes to the next one, that is maintenance of liquid assets and creation in the DRR. Now very simple. We saw that 30th April we will have to deposit a sum of minimum 20% which of the deposit maturing next year, and no time it should fall below 20% of the deposit maturing during the year. Register of deposits will be maintained containing all the details of the deposits, to whom it was given, their PAN numbers, the receipt numbers, the duration of the deposits, etc. Then comes premature deposits, premature repayment of deposits. Now, would you want to close your loan before? Would you want to make a premature closure? Prepay karna hai ya nahi loan? So here also the company is prepaying the borrowed money. Here they will subtract 1% and they will give interest to the depositors. See, understand, here what we are doing, whatever is the redemption period, the company is repaying earlier. So I will write here, it means early redemption. So obviously when you pay the bank early, you accept some benefits or no? You expect some benefits. Same way when the company is paying, then they will say, see, we repaid you much faster, so we also want some benefit. So then here up to 1% can be cut. Shall be reduced by 1% from the date when a company makes a repayment on request of the depositors. The depositors have requested early payment after the expiry of 6 months. So after 6 months, but before the expiry of the period during which it should be accepted, the rate of interest shall be reduced by 1%. That means early redemption cannot be done within 6 months. It has to be done after 6 months and before the tenure. The depositors are requesting for early repayment. So then 1% will be cut and it can be given to them. Not important. Then return of deposits is DPT 3 is to be filed on or before 30th June every year. Very important. So within 3 months from the end of the financial year, on or before 30th June every year you have to file with the ROC DPT 3. See here, all the dates are here. I've put out all the dates. all the dates and days are here. That is 30th June every year you have to file your DPT3. That means 3 months from close of the financial year. March done, April, May, June. Within 3 months of end of the financial year, you have to give a return of deposits. A return of deposits stating the details of how many deposits are there, how much is pending, how much is outstanding, how much is repaid. Okay, every company shall on or before 30th April each year deposit a sum of a certain amount with the scheduled bank. Each year deposit the sum, and the amount so deposit shall not be utilized for any amount except for this. No, you were reading this part. Here, this is the return, DPT3. Okay. Is for filing for a particular transaction, not considered as a deposit. So you can mark this as important. I have explained. Okay, when it has to be filed. DPT3 has to be filed on or before 30th June every year, containing the details of 31st March of that year. So पिछले साल के सारे details आ जाएंगे in the next 3 months. Disclosures in financial statements about how much every company shall by way of notes about the money received from directors has to be given. Penal interest rates, if the company has done a delayed repayment of deposit, then 18% interest will be charged. Applicability of sections, not important. DPT4 is for which were there at the time of commencement. Okay, now section 76 is going to come. So we've done 73, 4, 5, 6 and now 76A, which talks about the punishment. Punishment shall to the company shall not be less than 1 crore or twice of the amount of the deposit, whichever is lower, at a maximum of 10 crores. Fine not less than 1 crore or twice the amount of the deposit accepted, whichever is lower, and max amount that can be there capped at punishment will be 10 crores. And officers will get imprisonment up to 7 years and fine not less than 25 lakhs, but which may extend to 2 crores. So imagine such heavy penalties. So therefore you should, whenever you're issuing deposits, be very careful and compliant while issuing deposits. Okay. Now all the forms, DPT1 circular inviting deposits, DPT2 trust deed, DPT3 return of deposit, DPT4 existing deposits. Now there will come procedure. Procedure, I'll show you a very simple technique. You will be able to solve the procedures. First, you should know in the procedure that first articles of association should authorize. Second, you will have to do a board resolution, right? For board resolution, you will have to give a notice. Notice is in section 173. Okay. Then you will specify the time, place, agenda. Then as per LODR regulation 2930, before the meeting and after the meeting, this is before the meeting, this is after the meeting, you have to inform the stock exchange that you're going to hold this meeting. Next is then you will call a shareholders meeting. Now shareholders meeting, you will pass the resolution. If it is a special resolution, you will pass MGT 14. For calling the meeting, you will also have to dispatch a notice. Notice is in 101 and explanatory statement is in 102. Then you will convene the meeting. In with the notice will have the agenda, time, place, date of the meeting. Then after that you will have, after mentioning these facts, then you go to the provision. So always whenever you know the special resolution, then write all these sections and close. Then write the provision related to the particular to the concept. For example, we are talking of deposits. So in deposits, whenever raising deposits, you will have to write all the form number. You will have to write the form numbers. DPT 1, 2, 3, 4. You'll mention those. Then you will write the sections 73(2), the conditions, yes or no. Then you can write exceptions. If it is a public company, you'll write under raising from public, then you'll write about details about section 76. Then you will write certain rules. The deposit should maximum maturity, then the receipt of deposits, etc. Okay, so with this you will be able to build your answer, and then you will write that every year they'll have to file DPT 3 on maturity. They will then if it is secured, again very important, secured deposits are there, then that is secured by charge, so then the charges provision will apply, and CSG 1 and 9 will be applicable. Clear? Because you're keeping assets as security. Okay, so now if you read, you will come to know procedure. So a company may invite, they will have board meetings, then they will issue general meeting, they will pass a resolution, then whichever important, you can build up a concept. Okay, then obviously when you're issuing the DPT circulars, then you should give the credit rating as we've seen. So it is the just writing the provisions here. Filing of the DPT 1, then you have to term it as secured, unsecured if it is unsecured. If it is secured, then you will have to file CSG 1. Okay, then after the expiry of 30 days, then you can publicize. Then receipts within 21 days of the receipt or realization of check or money, then you will do. Pay interest of 18% penal interest if you paid late. Maintain register of depositors. Then again very important, the DRR. Talk about debenture deposit trustee. Write about repayment reserve. Minimum 20% should be going in the deposit repayment reserve. Then a certification from the auditors that they have not defaulted. Okay, then who all are exempted, what is the quantum, you can write. Then if it is from public other than members, so remember only eligible company, that is net worth of 100 crores and turnover of 500 crores can raise. Okay, then for them they will pass a special resolution. So you will have this, rest all the points will be same. Upload the circular and put it on the website. All the points are same. Checklist. As a company secretary also you will check whether the board meeting was held, whether general meeting was held, whether MGT form was filed, whether the DPT 1 was filed, whether DPT 2 was signed for the debenture, the trust deed was done within 7 days, entered. Then DPT 3 will come. Okay, DPT 3 has to be filed every year. DPT 4 if it is a existing deposits. 21 days from receipt of money you have to issue a deposit receipt. Okay, and everywhere it should come in the circular, and that it is under the instructions of the board that they are raising money. Clear? And then the particular resolution. Now resolution, I have shown a specific format. You can write it as per that format and it is very simple. Resolutions are where the board of directors or the company is resolving that yes, let's issue deposits. So how do you draft the resolution? Company secretaries do that. I have a separate session on drafting. In short, I will tell you, it will start with a title. Every resolution starts with a title. They will say resolution for. Then while starting, you will have to start with the word resolve that. That decided that pursuant to section, so you should know the section numbers, pursuant to section this and this, the company be and hereby has accorded that. Then you will write the company subject to such other approvals, the company has be and hereby accorded that. Now copy the title, to issue deposits of so much amount. Then you will write resolved further that. Then company has decided now who will do the work. XYZ person has been authorized to do such acts, these and things necessary. And that is it. We are done with the chapter. So I've covered everything, including the past exam questions which are there, and the entire chapter has been covered. Okay, so don't forget to hit the thumbs up, okay, if you understood this properly. Okay, yeah. Any other doubts you all have? Yeah, any other doubts, questions you all have? Okay. Okay. So now what we'll do, we'll take a break and then we'll start with another chapter, okay, and we'll complete it in depth. Okay. So just hit the like button if you like the video. Okay. Now I will start after the break another chapter. I will tell you what time I will start. So around 3 p.m. we will start with another chapter, that is our virtual meetings. PM we will start by virtual meetings. Clear? And we will complete it in depth. Okay. So I'll see you all after the break. Okay. Aparna, so you be in the groups and Telegram groups. I will be having one more just exam revision. That time you'll let me know. I'll cover those topics as well. Okay. Also in the groups, I'm sharing certain videos, etc., which will help you. Okay. Hi guys, so am I audible to y'all? Can you all just put in the chat box if I am audible and visible to y'all? And second thing is, you all can also go and join our Telegram group. Our Telegram group is pinned in the chat box. It is also there in our description. In the Telegram group and our WhatsApp groups, we send a lot of updates with respect to CS, revision lectures, and all the details you might need to clear these exams. Okay. So right now I'll be starting with another topic, that's your virtual meetings. In one go we'll complete and finish it off. Okay, so good to go. I just require you all to put in the thumbs up if or in the chat box if I'm audible to you all. Yeah? Okay, am I audible? Also, you can share the links because we have a lot of marathons that are coming up for the December 2022 exam. Also remember that even during exams, I'll be coming up with a rapid revision of almost all the chapters. Okay, right now I'm going extremely in depth. Whatever topic I'm picking up, I'm completing in a way that you don't have to worry, refer any other material, any other source. Everything in one go. Whichever topics I'm covering in like it is in regular lectures. Okay, good, great. So let's start, and also don't forget to join the Telegram group, the WhatsApp groups, which are given in our description. Okay, so let's start. Hi. So we'll be starting with virtual meetings. Now, what are virtual meetings? These are meetings done by the board of directors through virtual modes, maybe like a video conferencing. They have discussions. There are some discussions through voice conferencing as well. Now we will see under the Companies Act, where are all these provisions where we can have virtual meetings under the Companies Act. And second, you will also come to know as a CS today, when one of your director is in another country, another director is in another country, you are in some other part of the world. So how do you all connect, and whether Companies Act 2013 is allowing such meetings? Okay, so let's see. First, the provisions. Under the Companies Act 2013, shareholders are allowed to vote electronically. That is given in your section 108. Voting through electronic means very, very important. Second, when it comes to meetings of the board, that is given in your section 173. Like a board of directors meetings has to be 4 times in a year. So can these BOD meetings be done through video conferencing, and whether the directors who are participating from video from another part through certain audio visual ways, whether they will be counted in the quorum? All the details are given in section 173. Then we come to the rules. Okay, now when we come to the rules, you have 2 rules that you have to remember: companies meetings and powers of the board rules, rule 3 and rule 4. Rule 3 gives you the procedure and the steps to conduct a virtual meeting. Rule 4 gave you matters which could not be dealt through video conferencing. This has been repealed and has been removed through an amendment, and all the matters can be dealt with through virtual meetings. Okay, so rule 3 gives you the procedure. Rule 4 has now been omitted. That means all the matters can now be taken up through video conferencing. Now, for the rules for having voting through electronic means, rule 20 is there. Now when we come to secretarial standards, 2 secretarial standards I want you all to know. One is SS1, which is secretarial standards for BOD meetings, board of directors meeting, and SS2 is for general meetings. SS3 was for payment of dividend. Now SEBI LODR regulations are also there, which are applicable to listed companies. We will see what does regulation 44 says when they want to conduct meetings of shareholders virtually. It says that at least a one-way video should be given to the shareholders. And if you've seen the Reliance AGM, that is what they had done, where the meeting, the board of directors were present and their video was relayed of the AGM was relayed to all the shareholders through a one-way route. Now, when we start with the introduction, they are saying that in the present corporate scenario, companies are increasingly globalized, with members spread out not only in the various parts of the countries but throughout the entire world. Shareholders are not only shareholders of the area, but it might be of another state, of another country as well. Now, taking advantage of the information technology and all the softwares, Companies Act 2013 has enabled the directors to participate through video conferencing or other audio visual ways. Now, first, when we read chapter 12 of the Companies Act 2013, which talks about board meeting, section 173 subsection 1, what does it talk about? It talks about how many meetings should be conducted of the board. So the meeting should be conducted 4 times in a year, and the first board meeting should be conducted within 30 days from incorporation. And after that, every 4 meetings will be held in a year, that is 1 each quarter. Now these meetings in subsection 2 are saying that it can be held through video conferencing. So section 173 subsection 2 says that the participation of the directors may be either in person or through video conferencing or through other audio visual ways. And the procedure is laid down under rule 3, which we will see in some time. And when we come about voting, now voting for shareholders, where you and me are shareholders of so many companies, if we have to vote earlier, there we had to go to the company and then vote, remove our time, then take off from offices and go to the meeting. So because of that, what used to happen? The participation of shareholders used to be less. So as per section 108, voting has been provided through electronic means to the members and shareholders as well. So before we start, let's understand the meaning of the term virtual meeting. Virtual means what? Virtual means having without a presence, physical presence. So virtual meeting is a meeting where totally the shareholders or the persons are at different places by way of video conferencing. A virtual meeting is when people around the world, regardless of their location, use audio, video and try to engage in conversations. Virtual meeting allow people to share information and data in real time without being physically located together. In virtual meeting, no physical presence or participation is needed and there is no designated venue for the purpose of the meeting. So when you have a video conferencing, so many times we have conferencing with foreign clients. So both of us are holding a virtual meeting where none of us are there physically together. And virtual meetings are now becoming more and more common in the global environment. Now there are different kinds of virtual meetings that can be there. Okay, and I'm sure you have participated in few of them as well. One is audio, video conferencing, such as audio conferencing or video conferencing, online meetings, so Zoom meetings, etc. that are there. You have Google Meet, where we are having video, audio as well as video. Some of them are conference calls. What are they? They are like simply where there are no video. There is only audio conferencing where conference calls connects more than 2 people. Now video conferencing is a technology which is now being used in board meetings. So now when you go to see any kind of board meeting, the boardroom, they will already have a camera, they will have a LED display, they will have systems, hardware and software to conduct a proper virtual meeting. Now types of meetings, same time, same place, everyone has to be there. That's your conventional meetings. Same time, different place are all these virtual meetings that are there. Now what is the main benefit of virtual meetings? The main economic benefit of virtual meetings are it is efficient, it is saves time in traveling and also save cost in traveling. Another advantage is to hold meetings. It costs a lot of money, rentals, etc., which is all now saved with advent of technology. Now, softwares are used for virtual meetings. Now, if you see, they have not given Zoom because they're of it is a Chinese-based company, and there were some security leaks, security issues with respect to using Zoom. So companies nowadays prefer Microsoft Skype, Google Hangouts, okay, WebEx. You have certain seminars called as webinars now online. Now, brief requirements for a virtual meeting. Suppose if we have to conduct a virtual meeting, you'll require hardware and software. You will require meeting rooms which will connect everyone. There will be at least a company secretary who will be arranging, coordinating everything. There will be softwares such as WebEx, Google Hangouts, etc. You require hardware such as monitors, LCDs, web cameras, mics, okay, high quality mics, projectors, document scanners, leased line. Obviously, a good internet connection would be needed. Now, first we go to see meetings could be of meetings of the board and meetings of shareholders. Now, virtual meetings have been completely permitted for board meetings. Now, section 173, as we saw subsection 2, read with rule 3. Rule 4 has now been omitted, where it had given few list of transactions which could not be done through video conferencing. Rule 3 has given you the procedure for doing video conferencing and SS1 for board meetings. Now, SS1 defines electronic mode. Meetings can be done through electronic mode. Means what? Video conferencing or other audio visual means. So they call it other audio visual means. So they will use this term ahead in the chapter as well. Okay. Now, with online, very important is security, because if it is easily accessible, it could also be easily hacked, intrude, and there could be various data leaks which are there. So secured computer system should be there. Now, when I say secured means what? It has enough firewalls to prevent unauthorized access. It functions reliably, smoothly, without breaking down. Okay, it is suited for performing the intended functions. So whatever video conferencing you want, the software should permit you to do those, and it adheres to the accepted security procedures. Now, coming to timestamp. Now, what do you mean by timestamp? Timestamp records the time of the event, the place of the event, the all the details, the place, time, the date. All of those, a timestamp has to be done of these kind of conferences. So whenever video conferencing is done, we would know for how many hours it is there. We know what time it had started, what time it had ended also. So it's like a log. So current time of the event is recorded by the secured computer system, and it describes the time and is printed on the file to keep a track of the data with respect. In simple meaning, data is a digital record of the time of occurrence of a particular event. So it is a digital record of the time of occurrence of a particular event. Then if we see SS1, which talks about the secretarial standards 1 for board meetings, they had told that there are some restricted items which could not be done through video conferencing. However, as per effective from 15 June 2021, Rule 4 has been omitted, and all the matters which had said that could not be dealt through video conferencing, now all the matters can be dealt through video conferencing. So these were the matter which was earlier before the amendment could not be taken through video conferencing. Now it can be taken through video conferencing as well. Okay. Next, if we see the provides the notice in writing of every meeting shall be given to the every director by speed post, registered post, any kind of email, etc. Now, notice of board meeting. Obviously, if you have to give a notice of the board meeting where you want to tell what is the time, place, agenda, you could give it through physical means, also through electronic means. Okay. Next, notice shall inform the director about the option available to them to participate through electronic mode. So whatever notice we are giving, we'll also give an option, shall give an option mandatorily to the director that if you cannot attend, you can attend it virtually. If a director intends to participate electronically, he should also inform. So we will give an option to him. If he wants to exercise the option, he has to give us well in advance, or at the start of the year he will tell, and then it will be assumed that he will attend everything physically. If he has not mentioned anything, he has not even told that he will attend online, that means it will be presumed that he is going to attend physically. मतलब अगर उसने कुछ भी नहीं बताया, that means he will attend physically. If he has not told anything, that means he will attend physically. Okay, so that's suitable, because if you are attending online, you have to inform in advance so that prior arrangements can be done for online meetings. Now, the directors participating through electronic mode shall be counted for the purpose of quorum. Now, very, very important. Whether the directors participating online will be counted in quorum, answer is yes. Now, a chairperson shall ensure that the quorum is present throughout the meeting. If for some reason during the video conferencing, some of the directors logged out and it fell below the quorum, they were present before the meeting, they were present during the meeting, but sometime throughout the quorum meeting it was not there. If the quorum was not present throughout the meeting, then the director will have to adjourn the meeting. Attendance register. Now, attendance register is there where normally all the directors come and they sign that they've attended the meeting. But if it's a video conferencing, a roll call will be taken and they will have to give a answer to that yes, I'm present. Where are you sitting? The director will have to tell that, and from which place is he attending the conference. He will also have to confirm that there is nobody else who is not authorized to sit and hear the meeting. Okay, so we will see. Provided the attendance register shall be deemed to have been signed if their attendance is recorded through authenticated by the CS, and if there is no CS, then by the chairman present at the meeting. For the purpose, at the commencement of the meeting, the chairman shall take a roll call. Venue of the meeting. Now imagine if one is in Africa, one is in USA, one is in Japan, one is in India. So which is the venue of the meeting? So they say that the notice of the meeting should contain the venue, and that will only be deemed to be the venue of the. They will at least mention that it is the registered office. Okay, they will have to give the deemed venue of the place. Even if everyone is attending online, every single one is attending online, they will have to give a default location which is deemed to be the venue of the location. The scheduled venue of the meeting as forth should be given in the notice, and that shall be deemed to be the place of the meeting. Role of the company secretary. Now, company secretary ensures that all the online facilities are there, proper softwares are in place, proper notices have been sent, properly we have recorded who is going to attend offline. We'll ensure that the chairperson, the meeting is conducted carefully, proper minutes books are circulated. We'll have to ensure the integrity of the meeting, that it is safe and no leaks or hacking is there, to ensure that there is availability of proper audio-visual facilities available with the company, to record the proceedings and prepare the minutes, to store and safekeep all the tape recordings, to ensure that no other person other than the concerned director is attending the meeting, and to ensure that that the participants attending the meeting are able to hear and see, and the quorum is present throughout. Now I told you the most important section 173 subsection 2 permits audio visual ways. Rule 3 tells you the procedures for holding audio visual meetings. Okay, so this is the most important procedure. Now it's very simple. Directors may participate in person or through video conferencing to any other mode. Rule 3 provides the requirements for and the procedure for convening and conducting board meetings. So let's read. Every company shall make necessary arrangements to avoid failure of audio-visual connection. The chairperson of the meeting and the company secretary shall take due reasonable steps to ensure that there is a proper arrangement and there is no failure of audio-visual connection. The notice of the meeting shall be sent to all the directors. The notice of the meeting shall be sent to all the directors of the company, obviously. And that notice shall provide that they can attend through video conferencing as well. They will have to communicate, the directors will have to communicate to the chairman or the company secretary that they are going to attend the meetings online, so that prior intimation will help us take sufficient measures to ensure that we have given them online facility, to ensure that this internet connectivity is good, all those things. Now, any director who intends to participate through electronic mode, he may intimate about his participation at the beginning of the year, and such declaration shall be valid for 1 year. So he can, at the very start, he can say that I'm going to attend online only. Okay, provided such declaration shall not debar him from attending in person, he shall intimate the company sufficiently in advance of his intention to participate in person. Matlab, if you have told that you will attend online only, but then you physically went to the meeting, so that is also allowed. In absence of any communication, it will be assumed that he will attend in person. If he has not given any communication that he is going to attend online, means we will assume that he is going to come offline. At the commencement of the meeting, a roll call shall be taken by the chairperson, where every person will have to state his name, location, that he has received the agenda. No other person concerned has access to the proceedings of the meeting. Okay, the chairperson will confirm and take the quorum and ensure that it is there throughout the meeting. If at all, if the chair quorum is gone below the necessary quorum, a meeting has to be adjourned. The chairperson shall ensure that the quorum is present throughout the meeting. Now, with respect to this, every meeting, the scheduled venue shall be deemed to be the place which has been mentioned in the notice of the meeting. Notice convening the meeting shall be deemed. So the scheduled venue as set forth in the notice. मतलब जैसे नोटिस में बताया जो वेन्यू, वो डीम्ड प्लेस ऑफ वेन्यू होगा. Now, coming to statutory registers, shall be deemed to have been signed. Now, how will the director sign when he is sitting in some other place? So we are saying that the registers, attendance register is deemed to be signed if he is participating online, and online he has given his consent, that then it will also be recorded in the minutes. Next, if we see, every participant shall identify himself before speaking on any item of business on the agenda. Means what? Before speaking, I will have to say, hi, I am XYZ person, I am attending from so and so person, and I am going to speak on XYZ. If the statement of the director is interrupted or garbled, the chairperson, the company secretary, shall request for a repeat of the or reiteration, that is repetition of by the director. If they couldn't hear, they will tell कि आप repeat कीजिए, and he will have to repeat. If a motion is objected, the chairperson shall call the roll and note vote of each director, who shall identify himself while casting the vote. Now, casting vote also, the chairperson, if he is signing, he will have to identify himself that I XYZ am voting in favor of this proposal. Now, casting vote is given when there is equality of votes. between the two sides. Now, from the commencement of the meeting until the conclusion, no person other than the chairperson is required to be allowed to access the meeting. Obviously, nobody else is allowed except for the director and CS. Shall announce the summary of the meetings along with the names of the directors at the end of the discussion. Once the meeting is concluded, towards the end of the meeting, they will have to give the summary of the meeting. Now, very important about the draft minutes. Now see, you will see 15 days and 7 days. Now once the audio visual meeting is done, then the minutes of the meeting. What is a minutes? A minutes is the recording of the contents of the meeting. Recording of the events, what all was discussed at the meeting. Who was the chairperson, where it was done, who voted in favor, who voted against, which all resolutions were passed. The summary of the meetings is recorded in the minutes book. It is done by the company secretary. Now the draft minutes will be prepared by the CS and will be circulated to all the directors within 15 days of the meeting. Once the director gets, he gets 7 days to say whether the minutes was correct or no. Every director who attended the meeting shall confirm or give his comments in the writing about the accuracy of recordings of the proceedings of the meeting in draft minutes within 7 days after receipt of the draft minutes, after which it shall be presumed that it is approved. Means, moment meeting got over, within next 15 days it should be circulated. It got circulated to me. Now let's say it got circulated to me today. From today till the next 7 days, I have to say whether the minutes was correctly recorded or no. If I don't do, failing which, it will be presumed that I have no objections. Summary procedure for video conferencing. Roll call will be there. Directors will have to introduce themselves. Presence will be counted. Online presence is counted in the quorum. No person is getting unauthorized access. We have to ensure that. Differently able directors may have a person accompanying them. Directors to repeat if there is any disturbance. Chairperson may announce a summary. Minutes of the meetings will be given to the directors. Now, voting through electronic means. Now we saw board meeting, we are done. Now we are talking about general meeting. Now in general meeting also, whenever a matter is put to vote, we can put it through electronic voting. That is given under section 108. So this is also very important. In your meetings topic, it will be covered. Here there is a somewhat summary. As per rule 20 of the company's management and administration rule, every company which has listed its equity shares and every company which has not less than 1000 or more shall provide a right to vote through electronic means. So if there are 1000 or more members or listed company, they have to give e-voting facility to its members. Clear? Rule 20. Now SS2 talks about general meeting. Voting by electronic means casting by vote through electronic means from a place other than the venue of the meeting. Any member who has already exercised his votes through e-voting may attend the meeting but is prohibited to vote on the meeting and can cast his meeting as, and if he cast also, it will be treated as invalid. Mark it as important. If a shareholder has signed through e-voting, he can still allow to attend the meeting physically and even participate. But if he votes, it will be treated as invalid because he is already voted online. Next we see virtual AGM, EGM. Now understand, in our company law, nowhere will you find that we can hold video conferencing AGM, EGM. Video conferencing of board meeting is allowed, but not of shareholders meeting. Why? Because imagine the number of shareholders. How will you conduct it? Okay, so at everyone there can be disturbances. There can be facility to connect everyone. Okay, it's not going to be cost effective and will be very expensive to bring all the shareholders online. Okay. However, they are saying the advantages if this would have been done, you never know, this might be allowed. It will increase the participation, it will save the time of the shareholders, it will encourage more participation, it will bring greater accessibility who cannot access physically, enable institutional owners to protect the shareholders' interest, cost of holding shareholders meeting from the company point will go down, and company saves time of the company's personnel as well. Difficulties. Why we cannot hold AGM, EGM online? Difficulties in holding virtual meetings, security problem. It's very difficult to stream without interruption. Secured login is very difficult to provide. Okay, then data security issues will be there. Loss of device. Technology use must be given to all the, so even from the shareholders end, they will have to have software and hardware. Technology must be secure and the company must provide a digital record of the meeting. Now in present day, we have a one way is allowed, two ways not allowed. So we are following a hybrid mechanism currently for general meetings. As of today, holding of total shareholders meeting is not allowed. At present, hybrid meeting is permitted. Hybrid refers to those meetings where there is a combination of online as well as in-person meetings. Virtual meetings are those which are wholly conducted online. Total virtual meetings are not allowed. We have something which is of a hybrid nature for shareholders meeting. Now very, very important. Okay. Now as per regulation 44 of the SEBI LODR, top 100 listed companies shall provide a one-way live telecast of the AGM. So if you go to see, for Reliance meeting was entirely held one-way telecast was done. Top 100 companies determined by the basis of their market capitalization as on the date of their immediate preceding year will have to give a one-way telecast. So the AGM, EGMs are telecasted with few of them attending online also. Okay. Now also if we see a few points, that if at all a shareholder wants to participate, he can give his video and give it to the chairman or the company secretary, which video can be played, or if there is no time, it could, his question can be read out at the meeting. If a shareholder wants to participate, not physically, but he can give a note to the chairperson or to the company secretary. Okay, we can put them in a queue. If there are too many questioners who are going to ask, we can deny or limit the shareholders also. Okay, so that is it with respect to virtual meetings. Okay, let's see. See, these all FAQs are there. You can read it up. It's not that difficult or that it will be important. So how to accommodate shareholders who want to ask questions in large meetings? We can tell them to write it down and they can do it. Why the proxy is dispensed? Now very, very important, this part. Can proxy participate through online? Answer is no. Proxy is not allowed to attend video conferencing, because obviously the shareholder can participate through video conferencing at least. Is it required to give the venue? Yes, in the notice of the meeting, that would be the deemed place. For conduct of AGMs through video conferencing, that company holds the right to restrict the number of speakers depending on the availability of time. Are the companies allowed to restrict? Yes. The number of speakers can be limited to. Is it mandatory to share the question as in advance? Now this is important. For example, the shareholder says that let me attend online and I will ask, or let me come in physical and I will ask. I don't want to tell my question in advance. So is that allowed? Company is forcing him, no, you tell your question in advance? So answer is, you cannot force the shareholder. If he wants, he can directly ask the question. He might not want to tell you priorly. See, a shareholder may share his query as well in advance, so that if he could not be connected, it will be read out and answered. However, the shareholder may prefer to raise his query at the meeting only, and he does not have to share in advance to the company. How company keeps the registers open for inspection at this? If the company does not maintain registers online, nor it is scanned, in case the company registers are not maintained in electronic form, the physical records can be scanned in the virtual data room and given to the shareholders. What are the consequences if during the AGM chairman gets disconnected due to poor network connectivity and unable to join again? How the company can proceed with the AGM for the remaining items? Okay, if there is poor connectivity, it does not necessarily lead to adjournment. However, if the chairman is unable to join again, either you adjourn, or if they can elect another chairperson, that will still be fine. Do shareholders and directors have any right to ask recordings of AGM conducted? So recordings of AGM conducted is not mandatory, and only recorded transcript may be maintained. Therefore, a shareholder cannot ask for a recording of the meeting conducted through virtual meetings, even if the companies records the meetings only for internal purpose. Shareholder cannot demand a copy. Do the shareholders have any right to ask for the copy of the transcript? So these are public documents. Public companies have mandatorily uploaded the transcript on their website. In case the company has no website, they will not upload it and may provide a copy to the shareholder. As a good corporate governance, better to give. How to ascertain the quorum in proceedings or meeting? In case a person leaves the AGM, whether he would be counted for the purpose of quorum? So answer is, should be present throughout the meeting. It is the responsibility of the chairperson to ensure that they are there throughout the meeting. You can, it is mandatory to engage services of NSDL, CDSL for the purpose. You can also take, it is not mandatory to engage NSDL, CDSL. You can take private players like Zoom also for purpose. That is it with respect to this. Okay. Thank you. Okay. Now, one more important thing, you all can join the Telegram groups if you all haven't joined now. I've finished with the chapter. These are the questions. All you have to remember is rule 3 is important, 173 is important. Now, also remember that I will be again taking a very fast, rapid revision. Now, these are all detailed revisions where I've gone in depth. Rapid revision of all the chapters that will be closer to exams. Okay, so be there with me. You all can join the Telegram groups. Any other questions, doubts you all have, you all can tell me. Okay, so whichever chapters you're telling, I'm noting it down. I will take it up at the right time as well. Okay, so now I'll see you all tomorrow for the next marathon as well. Do share the video with your friends. I take these lectures in English especially for the students who prefer in English, like the students of the south. Okay, so please go share with your friends, bring them along, make them join the WhatsApp groups as well. Okay, so thank you so much for your time. Wish you all the very best. Continue studying. Thanks, Aparna. You are unable to download. Shubh, you are unable to download the admit card. What you need to do, there was a previous student also who had this doubt. Go to ICSI complaints. Okay, ICSI complaints and put up your registration number. You will get the number. You can do it. Sir, a lesson from part C. So which chapter I have taken, if you want, I will put up in the Telegram group or in the WhatsApp group. So let me know which chapter are you talking about. Okay, or when I'm taking the marathon, I will cover those topics. Okay, yeah. Thanks, Tara. Thank you. Thanks, Jack. Thanks for your time. Study well and let me know if you need any help.